Item 14.
Yes. It'll be after this item. Yes.
My Lord.
Yes.
Actually, my Lord. Here, my Lord. No rights of the petitioner has been violated, my Lord. There is no violation of right.
Last time you were arguing on delay.
My Lord.
Yes.
On delay, my Lord, on that very issue.
Last time
my
you
Lord
said it's a stale claim.
Yes,
the
yes,
petition was filed only in 2020, which is
Yes,
replied to, which gave rise to the cause of action of funded petition.
Filed in
when the right
2022.
accrued in 2007.
Yes, my Lord.
Right?
Yes.
Yes, okay.
So
And
on that
another
very issue,
point,
my
you
Lord,
said that
my Lord will-
the funds already been used.
My Lord.
Funds already been used, and so, it's only a, okay.
So my Lord will kindly appreciate, my Lord. In all these years, my Lord,
Yes.
there is not a whisper. It is not a case, my Lord, where the petitioners have been, my Lord,
Actively
receiving.
agitating the rights.
Not only that, my Lord, it is also not a case where the petitioners have been, my Lord, receiving their salaries under protest, my Lord. It is not a case. My Lord, they have been accepting whatever salary was being given to them without any protest at any point of time.
Yes.
So, my Lord, they are, my second limb of argument will be, my Lord, they are barred by doctrine of principles of estoppel.
Acquiescence.
Yes, my Lord, as well as estoppel. My Lord, these, if they had a certain right, my Lord, they ought to have asserted at a particular point of time. My Lord, it is not a case, they should, whenever salary was being given, they have accepted the salary without any protest. The petitioners has failed to show any occasion where, my Lord, they have accepted the salary without with protest. There is no whisper, there is no mention. So, my Lord, this writ petition, my Lord, in my respectful submission, is only an afterthought.
Fishing expedition.
Yes, my Lord. Because they have said that they wanted to, my Lord, approach this honourable court and see whether the reliefs can be granted to them or not. Because there is a question of delay, my Lord. So, even on that account, my Lord, they will be barred. Their claim should be barred, should stand barred.
Okay, yes.
My Lord, another point which I had harped upon even in the last occasion, my Lord. The petitioner has not given any computation, my Lord. What were they should have come out a little more clear, my Lord. That this is the salary we were expecting, this is the salary we got, this is the salary that should have been, ought to have been. My Lord, my senior has referred to section how it is to be computed, how the salary is to be determined, my Lord, but no such computation is there before us.
That's an important point, yes.
Because
that acts as a fact that they're literally fishing.
Yes,
in case something comes, then that onus will be on the government to.
Otherwise, they should have come clear that this is what I got, and as per computation, so they could have come to a certain computation on the basis of the rules, and then they could have said that this is what that we should have got.
They thought they were entitled to.
Exactly, my Lord. So only on the first instance, my Lord, this case should go. That by the simple question of my Lord delay, my Lord.
Yes.
Simple question of delay, simple question of no protest. So which means that you have accepted the fact.
Yes.
You have admitted, you have accepted the fact, you are okay about it. You raised this question only in the year 2020, and that cannot be allowed. My Lord, if that is allowed, my Lord, it is likely to cause a lot of difficulty for the government.
Well, on case-to-case basis, some kids have to be allowed also.
My lord.
That doesn't mean that, there's specific cases.
Now, violation, my lord, whether, now on statutory provisions, whether it is a statutory provision, my lord. In my respectful submission, it is the UGC guidelines. It's not a statutory provision, my lord.
But once they adopted the scheme, don't you think that it is binding?
So, my lord, if there is any, if there is, in my respectful submission, my lord, if there is any defect, my lord, if the scheme is not followed, the objection will have to come from the financing body, my lord. My lord, I had produced this letter on the last occasion saying there is the financing authority has released the fund only after scrutinizing the whole case, and thereafter the financing authorities have released the finance, my lord.
Yes. Yes.
My lord, at this juncture, this 7th commission is in existence to pay commission, my lord. Now, can they raise a claim, my lord, of an earlier, my lord, the UGC regulation 2010, where the subsequent regulation is 2018 regulation, my lord.
Yes.
So, my respectful submission, it cannot be allowed, my lord. If that be so, that anyone will come with a case at any point of time, my lord. There has to be some time bar, my lord. Now, as far as my senior on the other day had, my lord, argued that they have been given a very bad treatment, my lord. There is no such bad treatment. My lord, it is not a case of discrimination or petitioners have been given a separate treatment. No. All the state government teachers, employees, as well as the deficit school teachers, they have been treated at par. It is not a case of discrimination at all. It is not a case of, they cannot selectively come up and say that I have been treated differently. It is not a case. They have not been treated differently. Everyone has been treated at par. They cannot have, there is no question of discrimination here, my lord. Where is the discrimination? Where is the violation? In my respectful submission, my lord, there is no violation of any fundamental right, my lord. Whatever benefits are being given to all the teachers, you have received all the benefits.
Okay.
So, my lord, even even on aspects of violation, my lord, I would say that the case would not lie. There is no case.
No violation of any rights, you mean?
No violation of any rights, my lord.
Okay.
So, besides the other things, my lord, I will rely on, my lord, to that effect, I have also found two judgments, my lord, if I am allowed to place.
Please, please.
One is, my lord, 2008 SCC, my lord. My lord, the noting, my lord, service law, if I am allowed to read, my lord.
Yes.
Delay latches, court's direction to the department to consider stale claim, held court should be circumspect in issuing such directions as it ultimately leads to consideration of cases on merits at subsequent stages of litigation as if the cause of action stood revived due to fresh consideration. Further, held department can reject a stale case on the ground of delay alone without examining merits. Reply given to an individual does not give rise to fresh cause of action or acknowledgement of jural relationship. Observations made in a case where terminated employee submitted representation after 18 years and administrative tribunal directed disposal of representations within 4 months. In subsequent litigation, staleness of the claim ignored and relief given to employee because the department, in compliance with the court's earlier direction, had passed a detailed speaking order, representation and relief. This is a lot If I take my lord to my lord, if I take my lord to para 8, my lord, which is page 122. My lord, I'll take to para 9, my lord.
Yes.
Courts, tribunals proceed on the assumption that every citizen deserves a reply to his representation. Secondly, they assume that a mere direction to consider and dispose the representations does not involve any decision on the rights and obligations of parties. Little do they realize the consequences of such direction to consider. If the representation is considered and accepted, the ex-employee gets a relief which he would not have got on account of long delay, all by reason of direction to consider. If the representation is considered and rejected, the ex-employee files an application, writ petition, not with reference to the original cause of action of 1982, but by treating the rejection of the representation given in 2000 as the cause of action. A prayer is made for quashing the rejection of representation and for grant of relief claimed in the representation. The tribunals, high courts routinely entertain such applications, petitions, ignoring a huge delay preceding the representation, and proceed to examine the claim on merits and grant relief. In this manner, the bar of limitation or laches gets obliterated or ignored.
Exactly their case.
My lord. Every representation to the government, para 10, my lord, for relief may not be replied on merits. Representations relating to matters which have become stale or barred by limitation can be rejected on that ground alone, without examining the merits of the claim. In regard to representations unrelated to the department, the reply may be only to inform that the matter did not concern the department or to improve.
That is not important. Yes.
My lord.
Yes.
My lord, para 14, we are constrained to refer to the several facets of the issue only to emphasize the need for circumspection and care in issuing directions for consideration. If the representation on the face of it is stale or does not contain particulars to show that it is regarding a live claim, court should desist from directing consideration of such claims. The present case is a typical example of representation and relief. The petitioner keeps quiet for 18 years. After the termination, a stage is reached when no record is available regarding his previous service. In the representations which he makes in 2000, he claims that he should be taken back to service. So now my lord, reason for referring to this.
The court started a live claim.
Yes.
They have slept on it, whatever representation is unconsequential, and treating it again as a live claim, referring back to 2010 regulation when the new pay commissions come to effect, that is, they are barred.
Exactly, my lord. So that is my case, my lord.
Even if they are entitled at this stage, this should be thrown out the window.
My lord.
Okay.
Most importantly, my lord, will kindly see the conduct of the petitioner. Had it been the case, my lord, that they have been protesting from day one, that you have deprived me of a certain scale, this benefit I have been deprived. Maybe it could have been a different matter, my lord. You have slept over it, the government has utilized the fund, the reimbursement has come from the department, from the Ministry of HRD, my lord. Everything is done. Now suddenly in 2022 file a writ petition, 2020 you file a representation. Should that be entertained, my lord?
Okay.
And now you make a claim as if that your rights have been violated. Some statutory right. Which statutory right, my lord? So in my respectful submission, my lord, it cannot be allowed at this stage.
Okay. Yes. Next judgment.
my lord, this is 2023, my lord, SCC online. This is 1307. My lord, if I may take my lord to para 21 onwards, my lord. Profitably, we may reproduce relevant pages from certain decisions of this court. To summarize, my lord has got it.
Yes.
To summarize, normally a belated service. To summarize, normally a belated service-related claim will be rejected on the ground of delay and laches, where the remedy is sought by filing a writ petition, or limitation where remedy is sought by an application to the administrative tribunal. One of the exceptions to the said rule is case relating to a continuing wrong. In this case, there is no continuing wrong, my lord. My lord, in the next page, delay and laches. Delay and laches, my lord. This is page 8. Union of India versus N. Murugesan. The principles governing delay, laches, and acquiescence are overlapping and interconnected on many occasions. However, they have their distinct characters and distinct elements. One can say that delay is the genus to which laches and acquiescence are species. Similarly, laches might be called a genus to a species by name acquiescence. However, there may be a case where acquiescence is involved, but not laches. These principles are common law principles, and perhaps one could identify that these principles find place in various statutes which restricts the period of limitation and create non-consideration of condonation in certain circumstances. They are bound to be applied by way of practice, requiring prudence of the court, then of a strict application law. The underlying principle governing these concepts would be one of estoppel. These questions of prejudice is also an important issue to be taken note by the court. If I am continuing to read, my lord.
Yes.
The word laches is derived from the French language meaning remissness and slackness. It thus involves unreasonable delay or negligence in pursuing a claim involving an equitable relief while claiming prejudice to the other party. It is neglect on the part of a party to do an act which law requires while asserting a right, and therefore must stand in the way of party getting relief or remedy. Two essential factors to be seen are the length of the delay and the nature of the acts done during the interval. As stated, it would also involve acquiescence on part of the party approaching the court apart from the change in position in the intergenum. Therefore, it would be unjustifiable for a court of equity to confer a remedy on a party who knocks its doors when his acts would indicate a waiver of such a right by his conduct. He has put the other party in a particular position. Therefore, it would be unreasonable to facilitate a challenge before the court. Thus, a man responsible for his conduct on equity is not expected to be allowed to avail a remedy. So, my lord, and several others, my lord, have been referred in this judgment itself, my lord.
Okay. Anything else?
So, my lord, this is my main contention, my lord. The conduct of the party.
Anything else?
My lord, these are my main. Apart from that, my lord, of course, the other
Side
grounds
points.
that I have taken, my lord, in the
In the
affidavit that I filed and in my lord, the judgment which my senior had denied, which I had also pointed out, my lord.
Bharat Kumar.
No, my senior had relied on, my lord, Gambhir K. Gadvi.
Gambhir.
That was 22.5 SCC 179. My lord, there also, my lord, will kindly see. As far as the grant is concerned, it only says that if an authority is giving grant, we
You
have.
are drawing this judgment also.
My lord, I am only drawing the attention of this honorable court on that para, my lord. Para 27. My lord, it only says, my lord, I will take, my lord, to the last para, my lord. It further provides. This is page 98.
(198).
198, and the last line, my lord, it further
198, page
provides.
198.
198, yes, my lord. The last line, that is, it further provides, my lord.
Where is it? Yes, it further provides that.
It further provides that payment of central assistance for implementing the scheme is subject to the condition that the entire scheme of revision of pay scales, together with all conditions to be laid down by the agency by way of regulations or other guidelines, shall be implemented by the state universities without any modification. So, what it says, my lord, if that means whatever finance, you will be entitled to finance only if, my lord, only if you have adopted the everything in toto, my lord. That is the only saying of the court. But here the case for consideration before the Honorable Supreme Court is, my lord, is the qualification of the Vice Chancellor of a certain university, my lord. Now, in my respectful submission, that this will not have any bearing in the instant case, my lord. However, my lord, going into the very case, my lord, would amount to going into the merits of the case. But my respectful submission, my lord, even the merits of this case need not be gone into, my lord. Why it need not be gone into, my lord? Because this is a stale case, a stale claim. You are already barred by estoppel. You have approached this honorable court after a significant point of time, lot of delay is there. You have admitted and accepted your salary without protest. So, at this point, it has to be taken that you have accepted it. And at this point, you cannot raise this issue. So, my lord, in my respectful submission, my lord, this honorable court even need not go into the merits of the case, my lord. Only on the threshold it deserves to be dismissed, my lord, by this honorable court.
Yes. Pro judgment relying upon the same judgment that this Bharat Kumar.
My lord, the earlier which I had read, because I had stated that at that point, my lord, my argument was that
Was different.
no, it was in similar lines, my lord. But only thing is that there can be, it's not, I do not have to follow everything in toto, my lord. There can be some, state can make its own certain policy decisions, my lord.
Bharat Kumar. That 2007-11.
2007 is there, my lord. Then I had, my lord, also relied on 2022 SEC online. If my lord allows, I will give a compilation of the judgments which I have relied, my lord.
2022, which one? S-line, SC online 958?
Yes, my lord. That was what I had initially relied.
Yes.
Apart from these two.
How do you distinguish this? What lines you place in this one?
My lord, this was related to, so my lord, if I take, my lord, to para, my lord, para 12, which is at page 4, my lord. Para 12, my lord, learned counsel
Yes.
appearing on behalf of the appellants argued that the UGC Act and the UGC regulations enacted by the Parliament under entry 66 of the Union List under the 7th schedule of the Constitution of India, which pertains to coordination and determination of standards of higher education. So emphasis was to, my lord, to point out that the basic idea is to, my lord, for determination of the standards of higher education. Improve the quality of education, my lord. Again, page 7, para
What
7.
relevance does it have?
My lord, the UGC, the primary objective of the UGC, my lord, regulation is to,
You mean on its applicability, whether it should be taken as a statute? Or what is your point in para 11? 12, sorry.
my lord, here the main intention of this UGC regulation is to improve the maintenance
Of course,
of
it's
the
set up for
standards
that
of
only.
higher education.
Yes.
That is the main objective, my lord.
Right. So,
My lord, salary and all that is a part, my lord.
that's part
But-
of maintaining standard education also will necessarily involve salary also.
But my respectful submission, my lord, is mainly concerning the standards of education. That means, my lord, it will, my lord, have provide a guideline for the qualification of the teachers, appointment of the teachers, my lord, before they are, my lord, taken in for their service, my lord.
Even adoption regulation means that you can pick and choose which one to comply with and which one to not.
No, even assuming, my lord, that I have to follow everything in toto. So, my lord, if there is any defect or any fault, then that should have been pointed out by the MHRD. It was not done, my lord. The MHRD has given a finding that everything is in order. MHRD has not come up with a conclusion, my lord, that that you have not followed the everything in as it is in toto. So thereafter we refuse the grant. It's not that case, my lord.
Yes.
But however, again, that will amount to entering into the merits of the case, my lord.
So you want to skirt the merits at all, totally.
My lord,
You want just to on the
they are barred by estoppel.
okay. But earlier argued on merits, right?
Yes, my lord. At that point, my lord, what
You
was
had not prepared the case properly.
no, my lord. That point, what had happened, my lord, the instructions which I had relieved, my apologies, the instruction which I received, my lord, was that the UGC never gave any fund. But, my lord, subsequently, my lord, the department has given clear instructions, my lord. They stated that this was the fund that we received. This was the amount that was utilized by us, because fund is to be given subsequently, my lord. It's not it's not that fund will be provided and then you have to meet your expenditures.
Okay.
It is a case of state meets the expenditures. Thereafter, state forwards that this is the expenditure that we have made. So kindly give us the fund. So thereafter, a lot of formalities are there. So thereafter, after thorough investigation, inquiry, everything, only then, my lord, the fund is released. So, my lord will kindly see, it is relating to 2010 and it is regulation, and the period for which it is from 2006 to 10. Fund is released in 2016.
Period 2006 to 10, no?
Yes.
Correct, Mr. Sen. The period 2006 to 10.
Yes.
Correct for the that
It is for that.
5 years.
Yes.
6 to 10, no?
Yes.
Yes.
My lord, for now, my lord, apart from my lord.
For now, we're over. And this is a concluding.
My lord.
Today, I'm not going to. After today, I'm not going to adjourn the case
Yes, my
further. Like
No, I'm not adjourning the case, my lord.
I mean, I'm not
Subject to-
continuing any. Sorry, I mean to put another way. Not continuous hearing on any other date. This is a final date.
Yes, my lord.
Yes.
So, my lord,
Just send a reply.
Yes.
As of now, my lord,
No
I
replies.
depend.
Close it, huh?
My lord, as of now, my lord, I'll rest for now, my lord, subject to what my senior submits, my lord.
5 minutes.
I'll take little more.
5 minutes. 5 minutes. You already made your point.
No, my lord, limit. Because
With regard to
my
entitlement-
point, what I elaborately tried to cover, my entitlement. So I was expecting a elaborate submission on entitlement. Now my learned
says
friend
he is
has
not
foregone
entitled
that.
at all.
He's not on this. Court has picked up a point, limitations. Now he has shifted the gear. Now he is on limitation. So I'll have to answer. Entitlement, my lord, I will not trouble your lordship again, going back there. Because that is, I think, clear and very categorical, entitlement. I'm entitled. Now, in the facts and circumstances, was there a delay actually, your lordships? Can there be accusations estoppel against the statute? These are the things I'll only clarify, your lordship. Now, my lord, as I have been saying, my lord, to get a increment that is provided under statute, this is a statutory right. Now, what my learned friend submitted, your lordship also, my lord, inquiry, the regulation of the UGC was notified in June 2010. And admittedly, my lord, the scheme, MHRD scheme, that was dated, your lordship, 31st December 2008. Now, my lord, in the introducing paragraph of the scheme, very clearly and categorically states, your lordship, which I had taken, my lord, it categorically say the implementation of the scheme subject to the provision contained in the scheme as well as the regulation to be framed, future tense. That means when this scheme was formulated, the regulation was not in place. So that scheme categorically provided as and when the regulation comes, these will subject to the regulation also, my lord. Now, admittedly, my lord, the government of Meghalaya, by two letters, one is dated, my lord, 22nd March 2010, your lordship. Another is, my lord, 23rd March 2010. By these two letters, my lord, categorically they say they have adopted the scheme dated 31st March, my lord, 31st December 2008. And categorically mentioned they have extended the UGC pay scale. Now, my lord, I have stated, your lordship, UGC pay scale means this payment, then movement from one grade to another grade. Each movement calls for a increment. Now, my lord, that increment, how is to be calculated? Again, my lord, central government decision, which was incorporated in Rule 13 of the pay revision rules of. No, that is there, my lord, there is no dispute. Now, my lord, it is subject to that regulation. Now, one point has been raised since it was, and my lord, the UGC regulation, very interesting. UGC regulation came into force in June, notified in June 2010. Admittedly, my lord, after the adaptation by this. Now, my lord, does it mean, your lordship, these rules are not applicable? The rules are applicable. I should not make, my lord, a long submission on this thing. I'll just rely on a Supreme Court judgment, which I have already referred to, that Vice Chancellor's appointment, which
In
was
case you were showing.
which was set aside by the Supreme Court. You know, what happened there? The Gujarat, the state of Gujarat, my lord, same scheme. They adopted the scheme by a resolution dated in the year 2009. If I can take, my lord, There is in paragraph 7 of that judgment. The resolution was dated 11/11/2009. And UGC regulation came into force, my lord, June 2010.
No, answer that point regarding that 2010 to 20.
2010 to?
To 20, yes. After the resolution came out, then 2010, were rights accrued at that point of time.
Lordship.
And then 2010 to 20, what were you doing?
No, my lord, let me explain this, then I'll come. I'm just coming. I'll have to answer that. That has cast some doubt in the mind of the court. I can understand, your lord. I need to clear it.
Yeah.
I need to clear it. Now, first, I want to say this is a statutory right. And statutory right, there can be waiver. There cannot be, my lord, delay latches. There are certain situations. I'll come back to that. Now, my lord, in Gujarat also, my lord, this was adopted in 11/11/2009. No matter when before the Supreme Court. The Supreme Court categorically say you are bound by the rules which was notified in 2010, UGC regulation 2010. Further, my lord, this just to drive it home, my lord, in one paragraph Supreme Court has said, what the Supreme Court has said, this is an UGC regulations, and these UGC regulation, this is important, that's why, my lord, I'm saying, this UGC regulation, how it is framed. This is framed in pursuant to the power, my lord, conferred on the UGC under the UGC Act. And once it is prepared, this is laid before the Houses of the Parliament. And when it is ratified, your lordships, this becomes a regulation. And it becomes a part of the Act. So being a part of the Act, these become a subordinate legislation. Here all my rights are governed by legislation, not by a commitment of the state government or a cabinet decision. It's regulated by the regulations. And Supreme Court has held, my lord, it becomes a part of the Act and becomes a subordinate legislation. Being a subordinate legislation, what I am driving home, my lord, sanctity attached to the regulation. Supreme Court has further said, once it becomes a subordinate legislation, your lordships, since education belongs to the concurrent list, even the state government has a set of legislations. UGC regulation will override that. So, my lord, here there should not be any doubt that my increment is governed by a set of regulation framed by the UGC. There should not be any doubt. But this position has been clarified by the Apex Court in this judgment, my lord.
Which judgment?
This judgment.
By circular judgment.
That 2022, 5 SSC, my lord, 179. Lordship will come to paragraph 7. Paragraph 7, the date of resolutions. And, my lord, paragraph 50, regarding, my lord, subordinate legislation. Paragraph 50, my lord, speaks about subordinate legislations. Paragraph 50, 50.
Para 15.
Para 50, your lordship.
55.
50, your lordship.
Oh. It cannot be disputed.
Yes, my lord. It cannot be. Because lordship, para 6 or 7, I have said, the Gujarat also, my lord, much before, almost 1 year before the regulation was framed. Now here they have applied this, Apex Court has applied this regulation and they said it will be override any legislation by the state government and set aside the appointment of the Vice Chancellor. So, my lord, why I am emphasizing on this, to drive it home, that so far my right is concerned here, your lordships, I am governed by legislations, subordination legislation or otherwise. This is a statutory right, my lord. My learned friend has referred to delay and latches generally. What were the facts of that case? Termination, appointment. Appointment was challenged after 10, 15 years. Termination was challenged after 18 years. Those were not statutory rights, my lord. They were sleeping over the rights. Will the ratio of this case will apply here? Now, my lord, it is not in disputes. This right is a statutory right. Now, my lord, delay latches, my lord, so far statutory rights are concerned, will not come. What will come? Waiver. Waiver of a statutory right. It comes. Now, there may be a certain situation, my lord. I can cite an example, for example. Suppose a statutory rule say, an employee has the option to choose for a particular pay scale. They are given the option. You can choose for a particular scale, but there is no time limit. Now some employee is not exercising that rights for long time. And he was doing some other skill which is disbursed by the employer. He was sitting over it. Now after long lapse of time, he comes before the court or went before the authority. No, now I will exercise the option. Now the authority can say or the court can reject his condition. No, you were sitting over your right because you were given an option to exercise. You did not exercise for so long. We will not disturb. You have waived your right. Now here is what, my lord. Here the rule categorically say on placement, on a higher grade, you are eligible to earn one increment. That is by operation of law. It does not require an option to be exercised me. It does not require an employee to
Consciously waive the right away.
My lord, there is no. These cast an obligation on the authority to disburse it. It's not the question I should even ask for it. It is your duty, while fixing the pay, disburse it. If you are not disbursing, my lord, and not paying it at all for long years, what it calls for.
What are the consequences of not agitating for it and
My lord,
keeping quiet? Will
should
that
I-
amount to waiver also? Waiver of your right?
No, my lord, my humble submission, I'll come to that. Now, my lord, it is not required, my lord, that I should ask for it. It is the obligation of the state to disburse it. If you are not disbursing it and withholding it for a long time, I have filed a writ petition. I have not made a prayer for interest. If your lordship find it appropriate, my lord can impose interest.
That's
It's
different.
their fault.
That's different. That's different.
This is their fault.
That is a correct. No, that is not.
Now, my lord, coming back.
That is a single prayer. That's not. In
Lordship.
this case, it's
Now, my lord.
In this case, it's a distinct right which has been, conferred
Statutory
upon
right.
you.
Just not a right,
conferred
statutory right.
Distinct right. I would say
Statutory
exactly.
right.
Even then, distinct right. But then, you have not bothered about it.
No, that is not correct. I'll come back to that, my lord. I'll come back to it. My lord, he has not said a word about the communication made by the Directorate of Education, which is the competent authority. They said, yes, you are entitled. No, he should have answered this. He has not answered. I'll come to that, my lord. Now, if your lordship look into, my lord, that increment part. Now, increment when it is to be fixed, at the time of fixation of the pay. Very categorically mentioned in the rule, at the time of fixation of the pay. Now, what his affidavit say on this, yet to be fixed. There are anomalies. He has admitted first. If I can take my lord to page 6 of their first affidavit, your lordship. Five and 6. It starts from the bottom paragraph of paragraph 5, page 5. Bottom, if I can read, lordship.
Yes.
In this regard, it may be appropriate to mention here that as per the usual norms and practice, so far as pay fixation of the incumbents were normally being done by the respective colleges, the same are thereafter sent to the government for review. But in the recent times, certain objection has been raised by the Directorate of Law.
Neither here nor there.
My lord, I'm just coming finish. Regarding such fixation, as some anomalies have been found which requires regulation. Therefore, Education Department, along with local fund, audit fund, are in the process of streamlining the matter relating to the pay fixation of the deficit college teachers. So here they are admitted, fixation not done. Now, increment comes, my lord, at the time of fixation, not before that. Now that has been
No, it just says this.
lordship.
Some anomalies have been found, which require some anomalies have been found.
Anomalies.
Is there a question that fixation that
I don't know, but the fact is this: if your lordship, if I can take again increment, that part, my lord, to the rules. The question of increment comes when? If your lordship, if you can take, my lord, to page 79333, that about the increment.
Just read it.
And my lordship will simultaneously, for my lord, that will clarify the position. If your lordships take out that CCC rules, my lord, because we need to read it together. Where is that? My lord, at page 56 of my petition.
Mr. Sen, you do one thing. And you just give your bullet points.
My lord,
which
just,
side.
I'll not take more than 5 minutes now. This part, let me conclude.
You just, yes. Otherwise, you just give your bullet
13,
points.
13,
Court will take a call, yes.
13.
Just give the bullet points with all these.
Just my lord, I won't take more than 10 minutes. I'll conclude.
Sir, fine, now you come to 10 minutes.
13,
7933.
my lord, I'm referring to page 56. 56 is of the writ petition, is the relevant annexure. That is the, my lord, pay revision rules of the central government. Now paragraph 13. Lord.
Page 56 writ petition.
56 of the writ petition.
Yes.
Fixation of pay on promotion or after one. In case of promotion from one grade of pay to another, in the revised pay structure, the fixation will be done as follows. Now, there is called pay fixation. Now, here they are admitting pay fixation not done for some reason. It comes at the time of pay fixation. Now, when they file this affidavit, after I file my writ petition, now here it say at the time of pay fixation, this is the mode of calculating the increment and granting it. Lordship.
Okay.
Now, same thing, my lord, in the rules also say, my lord, how the pay is to be fixed as per the decision of the central government, which is incorporated in 13. So, in their affidavit, they are saying pay fixation yet to be done. There are certain anomalies. On the other hand, saying there is a delay, we are sleeping over the right. So, this is absolutely absurd and misconceived submission, my lord. Now, your lordship, coming back. Now, coming back to their notes, your lordship, he has read out only the things which he helped him. He has given lordship a notes. If your lordship look into the first page, the notings, I don't know who made the notes, the council or the government, I don't know. The very first page, your lordship, of the notes. Lordship has got it.
Oh, 1 second. There's one point, I'm just taking down for my own consumption.
Lordship.
Yes.
Now, this is regarding, we are concerned with six.
What are you reading?
These notes given by him.
My lord, on the last occasion when the matter was taken, on Friday, my
And
lord,
he is
when the matter
heavily
was taken
relying
up.
on those documents.
My lord, one of the document is already enclosed to the additional affidavit.
It's all
I
right,
had
my
made a
lord.
statement before this honorable court, my lord, that the other I could not include because, my lord, there was some time
Or no
constraints.
extension of revise.
Yes. Now, these notes, your lordship, now in the first paragraph it say, for 6 pay, Government of Meghalaya has released an amount of such and such. These are the central government, this. Now, lordship will kindly note the second paragraph. The above being the areas of UGC scale of pay and DA of the central government rates, along with areas on placements, increments. Now, he himself is admitted. This is meant for increments. Where is my increments, my lord?
Maybe in other.
No other increments, my lord. No other
This
increments.
is not only for you.
No.
The other colleges also.
My lord, now your lordship, I will come. No, some other college, some UGC teachers in some colleges will get increment, and then some teachers drawing the UGC scale in other colleges will not get the increment. It cannot be. It cannot be. Now your lordship, I will take, my lord, that letter. Letter dated 16 December 2016. Lordship has got it.
Yes.
Now, my lord, he has, what it say, first part, that we have looked into your adaptation order. We found your adaptation order is all right. I am not saying anything wrong with the adaptation order. Adaptation order very categorically say you are entitled for UGC pay scale. How the increment is to be given, that has been spelled out in the thing. There is nothing wrong. So if the MHRD has agreed with it, there is nothing wrong. But other part, why my learned friend has not read, lordship will come. The paragraph 2 onwards, I will just read it, my lord. The sanction of the President is hereby accorded to the payment of such and such to Meghalaya to enable to meet the additional expenditure involved in implementation of the scheme during the period this to this. The amounts would be utilized by the state government in accordance with the terms, conditions stipulated in department letter. That is, my lord, that 3112, 2008. Referred to in the above, and UGC notification 36/2010. What is this 36/2010? This is the date of notifying the regulation by the UGC. Again, they are reiterating. In December 16, they have disbursed this amount. Again, they cautioned and reminded the government, please go by this scheme and regulation. Now, my lord, 3, grant will be further subject to the following terms and conditions. Now, financial assets, these are not relevant, 80%, 20%. Lordship will kindly come to the next page of the type copy. There is a type copy and a Xerox copy, my lord. Type copy. Next page. If my lord comes to clause G, if I can read clause G.
Payment of central assistance.
Payment of central assistance for implementing this scheme is also subject to the condition at the entire scheme of revision of pay scale together with all the conditions to be laid down by EGC by way of regulation and other guidelines shall be implemented by the state government and universities and colleges coming under their jurisdiction in composite scheme without modification except in regard to date of implementation scheme. This is December 2016, Your Lordship. Again, they have cautioned, reminded, don't deviate from it. Now here, Your Lordship, I'll just point out, my lord, when we are placed in the higher pay scale, by an order issued in the last part, December 2014, but it was given a retrospective effect, 11, 13, and 14. 3 writ petitioners were there. That was the situation. Now, I am saying I have filed representations. Number 1, the question of increment comes at the time of pay fixation. Pay fixation was pending. They should have done it immediately. They kept it pending. Even now they are saying it's pending. They have not done it. I filed representation, fix my pay. Give me the increments. Ultimately, what happened, my lord? August 2020, Directorate of Education issues a letter, reference to my representation, acknowledging my right. They are entitled. Send it to the finance. Finance has not taken a decision. Now, my lord, interestingly, what is their reply to this particular communication in their affidavit, Your Lordship? At paragraph, they are not saying it is delay, barred and all, they are not saying. What they are saying, my lord? This is replied, Your Lordship, at page 15, paragraph 15, page 11 of their first affidavit.
Page 15?
Paragraph 15, page 11.
Okay, yes. That response.
My lord, if you can just read that in response to the amendments made in para 13, where I have annexed this communication of August 20th, the answering deponent states that by letter number such and such, a request may have been, well, it was a very casual answer, sent to the government to extend promotional increment. But the same is a matter of policy. What they are saying, this is a matter of policy. We don't care this statutory rights. We don't care this MHRD. They are not saying it's time barred. Now, can they improve a situation, my lord, when a statement has been made in an affidavit, when a communication has been made, which is a part of the record before this court? He's not even answered once what is this communication. Now, can it be improved by making an oral submission that this is time barred?
Okay.
So, my lord, this is a statutory right acknowledged in 2020. I filed a case in 2022, Your Lordships, and they are by making a statement in their affidavit saying that pay fixation is pending. The increment comes, my lord, at the time of pay fixation. Now, where is the question of, my lord, delay and laches? There is no delay and laches. This is a statutory right, my lord.
Okay.
Now, my lord, other thing your lordship is considering, well, these will have a huge effect. This will have a continuous effect. For example, my lord, I am saying, if I am not given a single increment, if my salary is not fixed in the appropriate stage to which I am entitled under the statute, my lord, I am repeating under the statute, legislation, then what happened, my lord? My subsequent revision of pay and all, these will get affected. The subsequent revision will be drawn on the basis of the pay fixed during the earlier structure of pay holding the field. So this is a continuous wrong, my lord. So my humble submission in
How
this
many increments would you have got if you had been granted them?
Lord.
5 increments.
one
How many increments you got? 1 increment for higher grade pay, that's all.
one increment. And again I am saying, my lord, this is off the record of Your Lordship. I just talked to, it comes to 300 to 400 rupees. Now, my lord, other thing is in Lordship's mind, here these will have huge consequences. Now, once Your Lordship holds that there is a statutory right, in the facts and situation there is no deal. Only because these will have financial consequences, my lord. Will my lord refuse to enforce my right? Lordship will
Once
not.
I establish the question, isn't that financing is not
It's not.
consideration.
Other thing he's saying budgetary allocation. Well, what I have to do with the budgetary allocation? His own notes is saying this is meant for increment also. Now, my lord has asked maybe some other increment. I don't know what some other increment. The lordship looked into the letter by which it has been disbursed. They have cautioned the government. Please follow it. And that was December 2016. This followed by a letter from the directorate. They acknowledge my right. No, let me finish, then you do. So, my lord, this is a case. Can this court, my lord, refuse to enforce the statutory rights? So, my humble submission, my lord, lordship need to enforce the rights,
Yes.
and direct them within a my lord time frame to grant me the relief, your lordship.
That is why we need a UGC on board then.
No, here again, my lord. Here again, let me clarify, your lordship. Lordship may hold that UGC has nothing to do right from
Of
the
course,
beginning.
if
No,
80%
that's my
component,
submission.
see,
My submission.
If
Your
80% components come UGC, Mr. Sen.
no, never.
And even this component also will be proportionately to come to UGC if the agreements are granted.
No, I'll
How
just-
now where the money come from now?
MHRD. Letter is there, your lordship. That's what we have read. 16 letter is there. This has been sanctioned by the central government, not by UGC. UGC, my lord, central government universities. UGC comes. State government UGC will not come. Now,
Let's see the letter 16. Where?
16, your lordship will see clearly. Where is the 16?
Let's see your petition.
Who's sanctioned? The sanction of the president is hereby accorded to the payment. UGC only for the power of the UGC regulation.
Kindly see, this payment is a disbursement. My senior is making it otherwise. It is a disbursement. Disbursement of the fund utilized by the state. State
See
has
the
already
contents of
utilized
the
the fund. My lord will kindly see. This is the fact. State has already utilized the fund.
That's only that's consideration.
Thereafter,
of-
the fund is
where
released.
will the money come from again?
Lordship, again I am saying. Permit me. Lordship may not accept my condition, nothing wrong. State of its own, from its own exchequer, because promise was this, if you implement this, 80% will come from us, 20% you will, that will be for 5 years. Now it came late. Initially, state spent from its own cover. It's not that UGC. UGC is nobody here.
Sorry, MHRD.
Right from the
Where's MHRD today?
MHRD is
MHRD, I have made them a party. I have served them a copy. If they do not come, my lord, if they do not come, that means they are not controverting the statements made herein. So, my lord, UGC,
lord,
this is
the
a. This,
So coming
let
down,
me
to,
finish.
okay,
Let me-
coming down to the brass tacks, your case is statutory right.
Lordship.
There can be no estoppel against law.
Cannot be.
It's subordinate legislation, and so right has accrued by virtue of adopting this 2010 regulations,
Lordship.
where the scheme of 2008, 31/12/2008 has been incorporated, and so your right flows from there.
Lordship.
Correct. And so, like, whether you agitated for it or not, or you sleep on it, is incumbent upon the respondents to give the payment.
Two more
Now,
things.
his case, that fine.
No, my
whatever
lord.
is-
It's two vital
if
points.
you-
I think Lordship, somehow, my lord, I could not place it. 16 letter, MHRD letter, when they sanction the money, disburse. Whatever is king, it doesn't make sense. Disburse. I say that. They have disbursed the money spent by the state. Because they were made the promise in the scheme. Now, that is by MHRD with the sanction of the president. UGC is not involved in financing, Lordship. There again, they have reiterated and cautioned. Follow the UGC regulation, follow the MHRD scheme. Don't deviate from it. That is, let me finish. You reply. My lord, let me finish. What is the problem? Now, my lord, they have cautioned them. Number one. Number two, ultimately, August 2020, my lord, Education Department acknowledged. They said, yes, we find it appropriate, and wrote to the government that they have a right to get promotional increment. They made a statement in their affidavit, because, my lord, increment comes at the time of pay fixation. Pay fixation is pending. Now, where is the delay, your lordship? There is no delay at all. This is my submission, your lordship. 2016 is a very vital piece of communication, my lord. Unfortunately, I could not annex, my lord. He has placed it.
Still by him.
It's placed by him, my lord. Now, that again reiterates. And so far, UGC, my lord, UGC has no role other than the, my lord, framing the regulation. Now, they have framed the regulation, that is nobody is questioning. Frame the regulation, we are supposed to follow. Now, money has to come from the MHRD, money has come. Maybe by way of disbursement. So, this is a fit case, your lordship will enforce the rights, my lord.
Yes. You give bullet points, yes.
My lord, if I may reply, respond.
And my lord, regarding those two decisions cited by my learned friend, my lord, their termination, challenging termination not statutory, appointment challenging after 10, 15 years, my lord, those has no relevance at all.
My lord, my senior, with due respect, my lord, had not produced any judgment.
3 judgments I have.
My lord, supporting, my lord, none of the judgments say that you can approach the court, statutory right, even assuming, though not admitting, statutory right, you approach the court after 10 years and it should be granted to you. There is not a single citation, not a single reference before this honorable court to support the claim of my senior.
If I am filing a petition in 2022 and 2020, they acknowledge my right. Where is the delay?
My lord, this is
necessary.
This is only the view. My lord will kindly see. Is a joint director, has written to the government. This is purely, my lord will kindly see, it is the view expressed by the joint director. He may be a government authority, but this is purely a view. Otherwise, my lord, he would have directed the government that please pay. What does it say, my lord? In view of the above, government is...
You don't have a judgment regarding subordinate legislation, right?
No. My lord will kindly see it said, is in view of the above... Please allow me. Gujarat is only... That Gujarat judgment is only relating to the appointment of the Vice Chancellor. That also challenging the qualification, my lord. It does not say anything else. It does not say anything related to scale of pay. In view of the above, the government is requested to kindly extend, my lord. This is his view, based on the letters which were being sent to him in the year 2020. What were they doing all these years, my lord? Kindly extend the promotional increment while promoting the teachers of both colleges, as well as deficit in 8 colleges from 1 stage to higher. So this is
engage in fishing expedition.
This is a request, my lord.
By sweeping over the rights.
Please let me submit.
No, court is asking me a question.
It is a request, my lord. We'll kindly see. Onus will definitely lie on the petitioners. You have approached this court after 10 years. I do not have the onus to submit my genuineness. It is you who have to show how you have been discriminated. Where is your calculation? You fail to give any calculation. You just make a submission that I have been deprived. How have you been deprived? Please show us how. From your petition, I cannot make any sense. Where is the discrimination? Which is the scale you ought to have got, what you have got, you have not made any calculation. I'm afraid to say, how do I make a submission? Had you made a calculation, filed a writ petition, maybe I would have got it inquired from the government.
Okay.
And my lord, as far as the scale of pay, my lord, my senior has referred to my affidavit, my lord. This affidavit, my lord, is concerning the present scenario, my lord. Recent times, what it says, my lord. My senior has referred to page 5 of the affidavit which I was filed, my lord.
The first affidavit.
First affidavit.
Yes.
Page 5.
Disregard.
In this regard, it may be appropriate to mention here that as per the usual norms and practice, so far, the pay fixation of the incumbents were normally being done by respective colleges thereafter, my lord, will kindly see recent times.
Seen that. This kind of anomalies, it happens all the time in anomalies everywhere.
Recent times, my lord. It does not say in 2010. Recent times, certain objections have been raised.
What is objections come everywhere?
And my lord, in the very affidavit, we have said that whatever is due to the petitioners, it has been given. In this very affidavit, the first affidavit, whatever is their due have been given to them. So my senior cannot rely on one paragraph which suits him and the other paragraph he will not mention. They have approached. So, my lord, thereafter they have approached this honorable court after a certain delay,
One
consequent
thing,
delay.
Mr. Sen, because I don't want to prolong hearing anymore. You file your bullet points and then you can supplement the authorities if you want. Just cite the authorities.
Well, I have cited all the authorities.
No more
All that, my lord, I am heavily relying on the communication. Only one thing
That's
you
the only thing you have.
No.
That's the only thing you have, Mr. Sen, the communication of the joint director.
Yes.
That's also whether it's been a contrived or it's under,
Dangerous,
sometimes.
dangerous. This is dangerous. Coming from the court is
Yes,
dangerous.
you don't
Dangerous.
know.
Why I am saying in every case.
Listen, contrived in the sense that without examining the competing rights. You understand?
No.
Now, whether the entitlement, no one's doubting it. Okay, the entitlement.
Delay.
The delay.
Delay.
That's what I'm saying.
All right.
That is why.
All right.
What I'm saying is answering representation without going to other aspects.
Right.
You please listen to the
No,
court
no.
fully.
Yeah, I'm
One is
listening.
contrived in the sense that, contrived in the sense that it's contrived to allow you to, to come to this court. Now this court has to weigh that also.
All right.
You see, I'm not saying that fine. Now, if a regulation is adopted, it should be adopted in totality. Now, the thing is that should have been factored in also, that you've been agitated for that the moment you got your promotional increment. So, if you're aware of your right that my promotional increment has been deprived, at that point of time, you have raised it. Now, after 10 years, you come and then say, okay, fine. And he doesn't look into the other aspects and says that it should have been implemented in totality. So, examine it. So that's the thing. So examining it is done by whom? Examined by them. They've not given it to you. So examine them by the court. That's all.
If I can stand.
Not contrive. You mean contrive in the sense
my
that
lord.
non-entitlement? No.
But this kind of things now keeps on coming, my lord. Whether way breach, my lord, something happened, communication, something. My lord, all these cases, these are coming up. Now here, your lordship, first thing, lordship, my lord, lordship will stand corrected. It's not 10 years delay, even otherwise.
Yes.
Lordship go by arithmetics. 14 placement was made by an order. 14 to 22, 8 years.
Anyway, you place
8
the
years,
points.
8 years, my lord, not 10 years. Number two, your lordship, if a official communication is made and that is placed on record, and if the affidavit is not questioning it, these cannot be, my lord, given a differentiate by making oral submission.
Whether one thing, Mr. Sen, you slept over your.
I have not slapped, my lord. 8 years, 2020 is there, 16, when the disbursement was made, MHRD has cautioned them. Follow it. Will your lordship ignore all these things?
My lord.
If your lordship ignore, my lord, I have nothing to say.
My lord,
16th December.
We're not ignoring. That is why the only point is regarding entitlement. I don't think this.
I'm not going into that, my lord. Entitlement, I understand.
My lord, we kindly appreciate. My lord, my senior is over referring to the letter, but my lord, that is regarding the expenses which is already incurred, my lord.
You file your bullet points.
It is not relating to expense which will be incurred, my lord.
Otherwise, file your bullet points.
And my lord, last one small thing, your lordship will see my prayer in the writ petition.
Yes.
I have made also a prayer, pay was not fixed. When the pay was not fixed, when filing the writ petition, so where is the question? Because increment comes at the time of pay fixation.
Lord,
Now, how this will be answered? But this is in my affidavit. They should have answered in their.
My lord, prayer itself is very vague, my lord.
Should have said, my lord, vague.
It doesn't matter. You file a bullet point.
It's a fact, my lord,
I don't
from the
want
record
to-
itself. I
continue
did not have to
hearing any
make
further.
any special development.
Yes. Yes, Mr. Sharma.
Yes, my lord.
Yes. Yes.
May I start, my lord?
Please start. Half an hour, finish.
Yes, my lord. At
Yes.
page number 35, my lord, is my casual leave letter, my lord, where I had requested for the leave, so sanctioning of my leave from March 23rd to March
20?
25th, 2020. March 23rd.
No, page.
35, my lord. 35.
35. Yes.
My lord, I had, through proper channel, I had asked for permission for granting me casual leave on March 23rd to till March 25th of 2020, my lord. And this fact has not been disputed, that my leave was sanctioned in a proper way. Even in the affidavit, they have admitted this fact that I was given a leave on March 23rd till March 25th. My leave was sanctioned. My lord, after I got the leave, I'm basically from Calcutta, my lord. So I went back to my hometown. The moment I went back to the hometown, my lord, the date March 23rd, the entire country was put into lockdown due to COVID, my lord.
Yes.
My lord, thereafter, I started giving mails to them, to the institution, from that is at page 36, page 38. All these are my mails to the institution where I have
But
stated
when you
that I have
came back,
left
when you
Shillong.
came back, you submit your application for leave after you came back to
My
Shillong.
lord,
So when you came back to
yes, my lord.
Shillong, when you came back to Shillong, did you submit your application for leave?
Yes, my lord. What had happened, my lord? I was allotted duties online to conduct classes, and I did. So, my lord, they wrote me a letter. That letter, my lord, will find at page,
Page?
my lord, at page 12, my lord. Oh, sorry, my lord, page annexure 12. Page 62, my lord. Page 62, annexure 12, my lord. This was issued to me on 5th October 2020, my lord.
That means from March to October, you didn't come to join the duties at all.
No, my lord. I was there in Calcutta. I was performing my duties online, my lord. And there is a record of it that I was performing online. And the online classes were also happening. That has been admitted in their affidavit that I was indeed conducting classes online, my lord.
No,
My lord, this was a.
why did they give the show cause notice then? Or no, show
I
cause
was never
warning
given,
letter?
my lord. That
Why
is
was this
the
letter
entire
given to you
issue.
then?
That was the entire issue, my lord. That despite the fact that I have been writing mails, that despite there's on record that I have been doing duties, they gave me an absence and negligence of duty. And my lord, there were circulars that was issued by the MHRD, by the government of Meghalaya, government of union government, that online activities should have been conducted at this moment of time. My lord, thereafter, my lord may see, after receiving of this letter, I have given them an explanation that on what basis I am not able to join and on what condition I
Where
will
is
be
that?
able to join. My lord, at page 66, my lord. This is my first application to them, my lord, on reply to their letter, my lord. So, since online teaching, learning, and work from home was allowed and encouraged in the pandemic situation, my lord, this is the second paragraph I'm reading from, arises due to COVID-19 as per the guidelines of NEHU government during lockdown unlock, I carried out all my assigned teaching duties online working from home at Kolkata and submitted my online teaching learning report regularly to the head of Department Zoology
Is
as per
that
the
correct? Is
prescribed.
that correct? Was our records are maintained? Okay, yes.
Yes, my lord, it is.
Continue. Continue, yes, continue. Yes.
Yes. Prescribed format of the NEHU as per the department, as per the on daily, weekly basis as per NEHU order. Further, I finished my entire assigned syllabus for the MSc and PhD course classworks online. I have also conducted internal assessment tests and set of question papers on the internal set assessment, which working from home at Kolkata. I have also examined the answer script and sent the marks in the online platform. I have also published one research paper in Scientist Journal. That although I was not physically present in the department, I performed all my assigned duties online and were always available to the department through phone electronic mode of communication. Considering all this, I humbly request you not to consider my physical absence as absence and negligence of duty from my part. My lord, thereafter, I further humbly state that I comply with your order to physically report and submit on my charge by October 12, 2020. However, the extraordinary situation beyond my control is preventing me to do so on my mother, who is 80 plus and a patient of so and so. After recovery, she again showing a low-grade fever almost every afternoon till then sometimes even 100 because of a low-grade fever. Because of this situation, she could not join in October 12. However, later on, she joined the campus on 11/12/2020. That is Annexure 17, my lord.
She joined
Page
when?
93.
11,
My lord,
12.
11/12/2020.
Join the duties. Join the campus
And in
physically.
between,
Now
yes, and in between,
that means from 20th of March you were absent. You came back to campus on December 2020.
yes, my lord.
Okay, that is on page.
Page 90, page 93, Annexure 17, my lord.
Okay, 93. Okay, yes. Then
My lord, at page 18, is there at Annexure 18, page 94, my lord.
'94.
Is
Yes.
the prologue? Yes, my lord. 94, Annexure 18, my lord. This is the council meeting, my lord. My lord, I may be allowed to read this, my lord. The
Yes.
council was apprised that Professor Bela Kishan, the petitioner, was out of station on casual leave from 23rd to 25th March after taking sanctioned leave permission from March 20th to 25th March 2020 to visit a hometown Kolkata. However, the HOD Nehu filed letter in the 16/9/2020 informed that the Bela Kishan is out of station on a casual leave and station leave from 20th March 25th March till 16th September 2020. And in between, Professor Kishan has sent some emails for grant of permission to work from home in view of the COVID-19 pandemic, lockdown, or other reasons, and that the emails later have been forwarded to the registrar for necessary action. Now the department has started examination related work beside other administrative responsibility to faculty members, and therefore Professor B is required in the department and needful to be done at the earliest. The matter of absence and negligence of duty was communicated to Professor Bela Kishan on 5th October 2020, the letter which I read before this, my lord, informing her that the authority has viewed very seriously for not being present report in the department and that she should report to the department immediately, latest by 12th October 2020, and submit her charge report through proper channel. She was further informed that the prolonged absence of the department till the date of resumption of duties will be settled strictly as per provisional rules only after joining of the department. My lord, thereafter, my lord, may at page 95 at the council resolve, the resolve, my lord, may see.
Yes.
And my lord, thereafter, at the 95.
Yes, yes.
Online duties from Kolkata.
When was this taken up? Which date? This resolution?
My lord, that is there in the affidavit in opposition also, my lord. This
No, the
resolution
date of the resolution.
Yes, my lord, I'm just.
October 2020.
This one.
15 October.
Where you get it from?
No, not 15.
16 December 2020, my lord.
Sorry, my lord, 16 December.
This is on Annexure 9,
16
of page 25 of the affidavit in opposition, my lord.
Annexure 18, okay, 16/12/2020.
Yes, my lord.
After you had come
So,
back.
my lord, yes, my lord. Now, my lord, at the end, my lord, may see that she was compelled to stay back in Kolkata, carrying out her duties online from Calcutta, and she finished entire assigned syllabus for the MSc and PhD work classes online, and also conducted internal assessment and set the question paper for internal test and semester examination while working from home in Kolkata. Now, due to serious sickness of her aged mother, she is requesting to allow to stay in Calcutta and extend her physical reporting in the department till such time doctor advised that her mother is medically fit.
No, this is
Thereafter,
not,
my
see,
lord.
one thing, Mr. Sharma, listen slowly. Don't have to get.
Yes, my lord.
See, you just read the last lines. In response to that letter, that response letter did 5/10/2020. Bela Kishan has furnished her reply that due to that she is compelled to stay back. Is not the observation. It's your reply.
No. Yes, it's not that observation.
That she
It's my
finished
reply.
entire syllabus for the MSc and PhD courses online. Also conducted internal assessment. She said requested so while working. That is what. Yes, that we've seen that letter you read now. Now what did they resolve?
That's the reply.
Yes, after
now see the council. My lord, may I continue, my lord?
Yes.
The council resolved that the establishment 2 section will examine her leave application as per existing rules and withholding her salary.
Yes.
They withhold my salary from the month of December 2020 onwards till finalization of her entitlement deduction of allowances during her leave absence from the quarter. My lord, how can they withhold my salary, my lord? That is the first illegality they conducted, my lord. Without any show cause, nothing, they withhold my salary. They put me in a position where I have to comply with their order. So thereafter, on 30th June, 6 months after withholding my salary, my lord.
How many months?
6 months, my lord, more than 6 months. After more than 6 months, on 30th June 2021, they released the letter to me.
Yes.
That is at Annexure 19, page 96, my lord. Page 96.
Yes.
As per your leave record, you are having my regulation of leave, my lord. My lord may see the subject, my lord. As per your leave, in pursuance of the Executive Council and resolution, I am directed to inform you that you are required to appear for proper leave for the period of your absence from the headquarter for 171 during the year of 2020. So they have already made up their mind that this is a period of absence. As per your leave record, you are having only 72 earned leave and 218 half pay leave at your credit. You are required to apply for leave as mentioned below in prescribed leave application format to be routed through the HOD at the earliest for further necessary action of the matter. My lord, this is the second illegality they have conducted. Because, my lord, an authority, how can they ask their officer or their employment that you give me the leave format in this to this format? Without any DPA being held, they have come to this conclusion that they will withhold my salary, there is a negligence of duty, and I have been absent from the duty. Where in fact, my lord, on record I can show where I have put the entire leave application, entire my appeal, where there are mails that have been forwarded that HOD has allotted me work is also there on record, my lord. Thereafter being, my lord, at page 97, annexure 20, my lord. May I continue, my lord?
Yes, yes.
My lord, because my salary had been stopped for a long period of time, my lord, with no other due consideration, I have to give my application for leave for extension of leave. And that I gave on 5th of July 2021. My lord, my signature is there on 5th of July 2021. My lord may see. They put me in a compelling situation in such a way by not giving me my payment, and then because I was in a position, my mother was already ill, was required of money, I have to listen to whatever they had directed me.
Okay,
Thereafter,
yes,
my lord,
yes.
My lord, at page 21, 99, 12 July 2021, my lord may see there was an order which was sanctioned, where is hereby conveyed to the order was granted, my lord.
Yes.
Have continued and thereafter, my lord, I gave my appeal. That is page 22.
Annexure 22.
Annexure 22, page 100, my lord.
Yes.
An appeal for condonation of the leave for the period of 28th May to 14th June 2020 from 11 July to 12 December 2020. And along with it, my lord, my entire content of work which I have done is at page 102, which is submitted to them. My lord, and on basis of that, there are emails that have been written, my lord, by the HOD. My lord, page 132.
Yes.
Correspondence with the head of Department Zoology, Nehu, regarding teaching the assigned topics on the paper to complete it. This is the head of Zoology, Nehu, writing to me, my lord. Dear Professor so-and-so, please note that after suspension of university classes, online teaching of university classes was again started around 10th April 2020. You are requested to complete the teaching of assigned topics of paper at your earliest to finish the course in time. Kind regards, A.K. Yadav, head HO. Thereafter, I replied, my lord. My lord, thereafter, again there are mail on page 133 that this is on 4th May 2020, my lord.
Okay, carry on. Then what happened after that? What happened to your appeal?
My appeal was dismissed, my lord, despite the fact that they have.
Where is that?
Yes, my lord. I apologize, my lord. My lord, that is at page 248, my lord.
Yes. Is it a reason order or no?
No, my lord, there is no reason order. It was just, I am directed to inform you, your appeal for condonation by your letter dated 29/10 was not considered and hence rejected. This is a simple line, my lord.
Right.
Thereafter, my lord, I wrote letter to the Nehu seeking representation upon representation for clarification and submitting my online work and for stating that all the works that I have given, I have already submitted to them. I again resubmitted, but nothing happened, my lord.
Yes.
And my lord,
Yes, anything else?
Yes, my lord. My lord, I would like to take you to the affidavit in a reply, affidavit in opposition of theirs, my lord. The only ground that they have rejected me, my lord. At page 3, my lord.
Yes.
Thereafter, by notification, at page 3, paragraph 5, my lord.
Yes.
Thereafter, by notification dated 4/5/2020, work from home was discontinued.
Where are you reading
Their
from?
affidavit in opposition. Their affidavit in opposition, my lord.
That while denying statements.
Yes.
Yes, my lord. That
Yes.
while denying the statement, yes, my lord. My lord, 1, 2, 3, 4, 5, 6 line, my lord. Thereafter.
Yes, okay.
Thereafter, by notification dated 4/5/2020, work from home was discontinued. And from 5/5/2020, 100% strength of Group A and were to attend and function from the office. But to avoid crowd and for maintaining social distancing as per the guidelines issued by the Government of India and the state government, online classes were allowed to be continued. So they are saying that because of these notifications, I had to report back to duty. But my lord, these notifications, I would like, my lord, this is a page, their notification. Annexure 4, my lord. At Annexure 4, page 17, my lord.
Yes.
This is a notice, my lord. Shall function in pursuance of the order of Minister of Home Affairs, Government of India, Government of and the order of State Government. Right dated, it is notified the officers of the university shall function. It is officers of the university, my lord. I am not an officer of the university, and I can prove that, my lord, by my reply where I have annexed it. Shall function with effect from 5/5/2020 with 100% strength of Group A and Group B officers, and 33% of the to Group C and Group D. In view of the limited public transport facilities, the university will provide bus service at designated place and picking and dropping. My lord, kindly, my lord, peruse my affidavit and reply with this regard, my lord.
Yes.
My lord, at Annexure 8, page 58, my lord. Page 58. This is the model cadre recruitment rules of non-teaching posts of Central University. Because this is a circular by the central government, my lord, not by the MO, Minister of Home Affairs. Page 58, Annexure 8 of my reply. My lord may see this is the model cadre recruitment rules of non-teaching posts on Central University. Now these are the group. My lord may see name of post.
How is the group A, group B post? Yes, okay. Yes.
Yes, my lord. There's a group A, group C. So the teachers are not there in this post, my lord. The research is, my lord. I am a professor. A professor does not belong here, my lord. My lord, now I'd like to take the guidelines, the COVID guidelines that were issued by the government and by the government of Meghalaya at that time. My lord, that is at page 21, Annexure 1, my lord. Page 20, Annexure 1.
Of the affidavit?
Of my affidavit in reply, my lord.
Okay. Yes.
My lord, this is MOHA order, whereas in the order of event number dated was issued for containment of COVID-19 for a period of 2/31/5/2020. Whereas exercise the power under 6(2), undersigned to issue an order to extend the lockdown in containment zone up to 30/6/2020 and to review open prohibited places in outside containment zone.
Okay,
Now,
okay,
therefore,
noted, yes.
Yes, my lord. So this was the time period they have been asking me to take earned leave, my lord, where I was working, my lord. My lord, now, my lord, this is at page 21 is the guidelines, my lord, where they have directly stated that school, colleges, at phase 2, my lord.
Yes, page?
Page 21, phase 2.
Yes. Yes.
School, college, educational training, coaching institutes will be open after consultation with state and UT.
Yes.
State government may hold consultation institute and other. Based on a feedback, a decision on reopening will be taken in the month of July 2020, my lord. MOH, Ministry of Home, will prepare SOP in this regard in consultation with the Central Minister Department and other stakeholders for ensuring social distancing and to contain the spread of COVID-19. Now, my lord, thereafter, at page annexure 2, my lord, page 28, the law, annexure 2, page 28, my lord.
Yes.
My lord, this is in continuation with the earlier guideline only. This is MHA guidelines for phase reopening unlock 2, 30th June 2020. MHA wide order number so and so had issued guidelines on unlock 2, whereby it had been
Okay, made
directed
your
that
point.
college.
Okay. With regard to the
Yes,
field,
my lord.
so that made it impossible for you to come again. Yes, Mr. Sen.
Yes, my lord.
Anything else?
My lord, one more. My lord, one more. My lord. There is also one issue with regarding to my pay fixation, my lord. That is, my lord, this is very much clear that how much of irregularity they have done with me, my lord. My lord, at page 31 of my writ petition, my lord. Kindly, my lord.
Is it part of your prayer?
Yes, my lord, it's been part of my prayer, my lord. Annexure 31, my lord, page 260, my lord. 260, my lord.
Annexure 31, page 260.
Yes, my lord.
Let's see your prayer first. 1 second.
Yes, my lord.
Correct wrong fixation.
Yes, my lord.
Now, once they condone the leave, if they
Third
condone the
prayer,
leave,
so
then
that
your
wrong
fixation will be done normally. Yes, what page? Page?
My lord, page 260, my lord. Annexure 31, my lord.
216.
260, my lord.
Oh, your local council. Very good. Yes.
260, my lord.
Yes.
This is pay fixation anomaly, my lord. Please find enclosure details regarding pay fixation anomaly with specific information as per given format. My lord may get it, my lord.
Yes.
Yes, my lord. Thereafter, I gave my, at 261, I gave my pay fixation anomaly, my lord. My lord may see, my lord, at serial number 3, I got appointment in Nehu as reader on 19/4/2007, and my entry level pay was fixed at 22,320
Is
in
this
pay
pay
band.
fixation connected to your leave for condonation of leave application?
Yes,
Is
my
it
lord.
connected or is it connected or not?
It is, my lord,
Is it
because all my
connected? If
representation.
it's not connected, then it has to be a different cause of action.
No,
It
my
can't
lord,
come the first.
while,
It can't come pay fixation if it's not connected. If you say that there's been pay anomaly with regard to since your initial date of joining,
yes, they have not been giving my initial date of joining, my lord.
then that's a different interpretation. Anything else, Mr. Sharma? Any
My lord,
authority?
authority,
Yeah.
my lord, with pay fixation, my lord, it has been, they have been debarring me from pay fixation from May 2000
Not pay
onwards.
fixation. Why how can it come? How can you club two cause of actions into one writ petition?
My lord, they have also not, they have not commented anything on that, my lord.
Why should
That
they
they have
comment?
not
They
even
won't comment on it because it's not part. You're asking for for condonation of your absence period. Not to not.
Yes, my lord.
Yes,
That is my main prayer, my lord.
then
That is
that's
my
the main
main
prayer. You
prayer.
can't push the other prayer. Other prayer you will at liberty to agitate it in another forum, another petition.
My lord.
Yes, you reply tomorrow.
Tomorrow, Lordship. Not tomorrow, my lord.
Tomorrow, short reply.
Those matter, my lord, that the interim way bridge and all are there. Lordship, if your Lordship can post it on Thursday, man.
After tomorrow then. Hearing of list on today is 12th.
My Lord, 14th.
Yes. 14, short reply.
15th, Your Lordship.
Okay, 15. Short reply only
Yes,
on
yes,
that
I
point.
will make it.
Because only thing is, see, the thing is that if the situation as it prevailed at the time was such, and so that whether, in the circumstances, whether the only thing for you is to, as per the records, whether she conducted classes or whether she was in duty, that's the only thing. That's all.
No, we have
My
stated.
Lord, may I just,
We have made
my
a
Lord, may I just
categorical
pray?
statement.
My Lord,
Yes?
may I just pray? Can it be on 14th, my Lord? On 15th, my Lord, there are some matters in the High Court, my Lord. That is.
Then let it be 16th, Your Lordship.
16, last day, no.
Then let it be Monday, my
No,
Lord.
no, no. Then if you, let it be on 15 because arrest 14 or 15.
15th, then let it be 15th, my Lord.
15, let your local council be here.
My
Otherwise,
Lord.
it'll go to 19th. 19th then? 19th, okay?
My Lord, yes, my Lord.
19th, yes. Hearing conclusive.
Lordship, 19th.
Fix on 19th for further hearing, yes.
Oblige.
And the earlier one, please file your bullet points
Then
within.
short bullet, my Lord.
Yes.
In 2 days, I'll find.
But that one, that delay part, satisfactory part, is only part that troubles the court. Otherwise, entitlement.
My Lord, I'll.
Yes.
Much obliged, my Lord.
Yes.
They are saying